Good morning, ladies and gentlemen. I am Mr. J. N. Ambikar, a retired superintending engineer from Government of Goa, and subsequently worked as a contract specialist with JICA assisted project for Goa Water Supply and Sewerage Board, and I am empaneled arbitrator with CIAC with the blessings and encouragement from CIACs, particularly Mr. Swarup and Mr. Professor Gupta. I am proposing to present before you the changing landscape of arbitration in India, suggested interim measures for speedy implementation of the amended Act. At present, ease of doing business in India is the buzzword these days to impart necessary momentum to the economy. Settlement of commercial disputes through speedy, inexpensive and effective arbitration plays an important role in this endeavor. Accordingly, the Arbitration and Conciliation Act has been amended in 2015 and 2019. The Arbitration Council and the Arbitration Council of India, a regulatory body to control arbitration in India, has been introduced by the amendment in 2019. By the ordinance dated 4/11/20, the 8th Schedule of Principal Act has been omitted, and norms, qualifications, experience for accreditation of arbitration will be as specified by the regulations. In view of the expected time required to set up Arbitration Council of India as per the provisions of the Act as amended in 2019 and making it fully functional to control the arbitration in India, interim measures are required to implement the amended Act within short time with due considerations to the settled law as per the relevant court rulings. This calls for convergent and valued considerations of the authorities from the Ministries of Law and Justice, Commerce and Industries, and Finance in particular. I attempt to answer the above points with focus on speedy implementation of the Act to the benefits of stakeholders, which in turn will benefit accelerated economic growth of India. A cursory look at Arbitration and Conciliation Act 1996 as amended in 2015-2019 and the relevant ordinance dated 4th November 20 will reveal that the Arbitration and Conciliation Act has been amended in 2015 to make the arbitration cost effective, user-friendly, minimum court intervention and expeditious disposal of cases with a view to improve legal framework in India in order to make India investor-friendly country and attract foreign investments in India. The Act was further amended in 2019 to promote institutional arbitration to prepare roadmap for making India a robust center for institutional arbitration, both domestic and international, after examination of specific issues affecting the arbitration landscape and identifying roadblocks to the development of institutional arbitration by the high-level committee under the chairmanship of Justice B.N. Srivastava. In this context, especially the Section 11 of the Act in particular emphasizes that in respect of those high court jurisdictions where no graded arbitral institution is available, then the Chief Justice of the concerned High Court may maintain a panel of arbitrators for discharging the functions and duties of arbitral institution, and any reference to arbitrators shall be deemed to be an arbitral institution for the purpose of this section, and the arbitrator appointed by the party shall be entitled to such fee at the rate as specified in the 4th schedule. The important points with reference to the arbitration and appointment of arbitrator will be mainly Section 11(8) of the Act, which provides that the arbitral institution referred in the subsection 4, 5 and 6 before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to any qualifications required for the arbitrator by the agreements of the parties and the contents of the disclosure and other considerations as are likely to secure the appointment of an arbitrator, independent and impartial arbitrator. The emphasis of Section 11 is on the terms of agreement being adhered to and or given effect as closely as possible, which needs to be considered while appointing the arbitrator. Supreme Court decision in respect of Railways case 2008 Old Trust Pines case 2017 and Central Organization for Railway Electrification case of 2019 are relevant in this particular context. Therefore, keeping in view the paramount principles of arbitration, namely fair, speedy and inexpensive trial by an arbitration tribunal, party autonomy in the choice of procedures, etc., such power is exercised by the court while considering the application under Section 11 for appointment of arbitrator or constituting the arbitration tribunal. Only in exceptional circumstances like abnormal delays, the court can appoint the independent arbitrator in such exceptional circumstances by keeping aside the stipulations in the arbitration agreement, but not as a default procedure, such as failure of persona designator to appoint the arbitrator, arbitration tribunal as per the agreed procedure, and that too after recording the reasons for exercising such powers. Further, the Section 1110 as amended in 2015 has been omitted by 2019 amendment, thereby removing the powers conferred on the Supreme Court or, as the case may be, the High Court to make the scheme for the appointment of arbitrators. The court may not make such scheme. Uniform approach to such schemes by the arbitral institutions is necessary to be controlled by the Arbitration Council of India. In light of the present scenario, the summarized points to ponder emerges as, in my opinion, are as under. Number one, the arbitral institution designated by the Supreme Court or High Court does not have any judicial power. They cannot appoint independent arbitrators like courts. Secondly, the amended Act is in place while the Arbitration Council of India with infrastructure as per the Act is not in place. Number three, existing arbitral institutions having their own set of rules and procedures for appointment of arbitrators need to comply the statutory requirement of the amended Act and get designated by the respective courts in order to function within legal ambit. There are 37.44% vacancies of judges existing in 25 high courts as on 1st of October 2020, which also contributes to delay in appointment of arbitration tribunals. This burden of High Court needs to be reduced by minimizing such references to them. Therefore, the scenario which emerges, in my opinion, will be like setting up an Arbitration Council of India as per provisions of Act as amended in 2019 and making it fully functional to control the arbitration in India, need administrative procedure to be followed as per the statutory requirements spelled out in amended Act. To me, it appears that it would take considerable time. Secondly, the parties willing to settle the disputes through arbitration will have to either go by the arbitration agreement wherein an arbitral institution designated by the court as per section 11(3)(a) of the Act and its laid down procedure is specified for securing appointment of arbitrator, followed by conduct of arbitration leading to the award. Or second option is to approach the High Court for appointment of arbitrator, even if arbitration agreement authorities one of the parties' officer to appoint the sole arbitrator or a tribunal from its panel of arbitrators, barring the provisions of section 12(5), of course, read with 7th schedule of Act, in order to settle the disputes through arbitration as the party cannot act for such appointment as per the Supreme Court decision in Perkins case 2019. We find that major organizations like CPWD, MES, NHAI, PSUs, railways and allied service sectors and externally funded projects following FIDIC form of contracts are all affected for resolving the disputes through institutional arbitration. The projects on PPP boot basis, externally funded JICA, World Bank, IDBI, etc. projects with tri-party funding agency, contract agency, Government of India and state government long-term funding agreement having investor funding pattern and his interest playing pivotal role get adversely affected if dispute settlement mechanism as contemplated in the amended act is not in place. This apart, the financial burden due to arbitration and litigation is generally on the borrowing country, state government. This is bound to cause a dent on the smoother cash flow and system of financing drawn up by the state government for all such development works. In light of statutory provision, Section 11, subsection 3A of the amended Act 2019, gradation of arbitration institutions, which is sequel to the action by the Arbitration Council of India in pursuance of Section 43I of the Act. Therefore, it becomes absolutely necessary and urgent that the Chief Justice of each of the High Courts will be required to maintain a broad-based panel of arbitrators, particularly in view of the substitution of 43J through the ordinance dated 4th November 20, with due consideration of the letter spirit of settled law in the Supreme Court case in respect of Ulster Pine in 2017 for discharging the functions and duties of the arbitral institutions. This will strengthen wide choice of neutral, impartial arbitrator and party autonomy for choosing the arbitrators according to the nature of disputes. If these panels are available with the High Court, accessible to the parties who desire by an agreement to settle their disputes by arbitration, the choice of arbitrator to be appointed will be appropriate, while undertaking under Section 12 will help decide his ability to devote sufficient time to the arbitration and in particular his ability to complete the entire arbitration within the specified time as per the Act. As per the Act, the need of the hour is to impart speed and uniform approach to each settlement selection of an arbitrator or constituting arbitration tribunal from broad-based panel of arbitrators in line with the amended Section 43J of the Act to be available with the High Courts. The parties to brief the court about the nature of disputes to select an appropriate arbitrators to secure appointment of arbitrator under Section 11 of the Act. Similar broad-based panels of arbitrators can be developed by the existing arbitral institutions spread across the country. Roping in Chamber of Commerce and Industries, Confederation of Indian Industries can also play an important and pivotal role in almost each and every state of Union of India. These existing arbitral institutions and CCI, ICC centers having infrastructure in accordance with 43I of the Act, as well as panels of arbitrators as amended as mentioned above, can be recognized as graded arbitral institutions by the Supreme Court or High Court on the ad hoc basis until such time Arbitration Council of India is set up as per the provisions of the Act as amended in 2019 and is fully functional. The localized or regional stakeholders will be largely benefited by such facilities and competent arbitrators available to them at ease. It is true that all this above procedure may take some time, so we must consider the optimization of time factor to achieve above targets. In my opinion, the central government can direct Supreme Court or the High Courts through the Ministry of Law and Justice to take measures for developing broad-based panels of arbitrators in line with the amended Section 43J. In the similar way, the Ministry of Commerce and Industries may advise state-level chambers of commerce and industries or level entities or similar entities to develop facilities in compliance with the amended section 43J, as also for developing broad-based panels of arbitrators in line with the amended section 43J. The central government may then grade them as arbitral institution to be designated to be by the Supreme Court and High Court as per section 11(3)(a) until such time Arbitration Council of India is set up as per the provisions of the Act as amended in 2019 and is fully functional. Once these requirements are accomplished in one and the same time slot by parallel actions in a time period of say 3 to 4 months, the parties willing to settle their disputes through arbitration can either approach these institutions or High Court for appointment of arbitrator and subsequent proceedings leading to the award. Therefore, in conclusion, I must submit that the above measures will ensure intended landscape of arbitration in India taking shape in an accelerated speed without any compromise to the law established and help improve ease of doing business in India, resulting in strengthening the economic growth. This will remain independent of establishing Arbitration Council of India, emerging as a robust controlling body corporate in due course of time with all necessary infrastructure in place. The stakeholders and investors will be happy while the high courts will have less burden on account of arbitration referred related matters. Thank you for patient listening. Jai Hind.